Good afternoon, members. You're all very welcome. I'd just like to remind you that the meeting is being broadcast online and throughout Parliament buildings. Just like to welcome those people who are watching online today. If you can ensure your mobile phones are muted, and just to remind you that recording and photography of the meeting is not allowed. Okay, we're content. I'll proceed. Okay, so have we got any apologies today? No, Chair. Okay, so I think we are expecting a couple others online. I think maybe one of the committees is running late. Any declarations of interest to record over and above what we have on record? No? Okay, thank you. Okay, Chairperson's business then. So 3.1, Truth Recovery Independent Panels, and I'm going to refer you to page 6 of the meeting pack. Okay, just to advise members that £80,000 was spent on a communications campaign aimed at raising awareness of the testimony gathering process and the £1.5 million capital Dell earmarked funds in respect of the Truth Recovery. These are detailed in the email citing the extract of the Hansard report from the meeting on the 26th of March. Just like to remind you that at last week's meeting the committee discussed the extension of the term to the panel until March 2026, and members had queries regarding its outreach initiative, especially in relation to leaflet distribution and its expenditure. And just to advise, the committee has written to the department to request a breakdown of the £80,000 regarding the comms plan, including the geographical spread of the activity, and the clerk has also contacted the panel regarding these queries, as they will be appearing before the committee at next week's meeting. So are we in agreement that we will note this item for now? Okay, thank you. Okay, so 3.2, call for evidence. Just to advise members that the committee's formal call for evidence on the bill has now closed, and 59 responses have been received via Citizen Space, and 20 written submissions have also been received. I just would like to seek your agreement that, as some people requested hard copy versions of the call for evidence, some of these do remain outstanding, and I would suggest that we set a deadline of next Monday, the 6th of October 2025, i.e. 7 days from the original deadline, is put in place for receipt of these responses that we're expecting through the post. Okay, we in agreement? Yeah, okay. So I'm just going to advise that the clerk will update the summary and emerging themes paper, and this will be included in the future meeting pack. And I just would like to take the opportunity to thank everybody who has contributed to the call for evidence on our very important bill. Your submissions have been excellent, really, really useful, and they will certainly assist us in the scrutiny of this bill before us. Okay, moving on, members. Welcome online, Carol. Thank you for joining the meeting there. So, item 4, just to advise you that the draft minutes of the meeting held on the 24th of September 2025 are found on pages 71 to 80 of the pack. And I just ask if you're content that these minutes are a true reflection of the proceedings of the meeting. Okay, content? Okay, so I'll go ahead and sign the minutes. Matters arising. So 5.1 to 5.4, these are the responses from the Health Trust in relation to access to records. So I'm going to refer you to pages 82 to 98 of the pack for the correspondence that was sent to the 5 trusts on the 23rd of May this year in relation to access to records and the inquiry Mother and Baby Institutions, Magdalene, Laundries and Workhouses and Redress scheme bill. So just to advise that the Belfast Trust is still outstanding, and the committee has contacted the Trust following last week's meeting to chase up their reply for the committee. So I'm just going to ask your agreement again to wait for this response from all the trusts before writing to the Health Minister outlining the concerns surrounding service delivery and difficulties in accessing records as detailed in the Trust replies to date. Are we in agreement? Yeah. Sorry, I'm going to take Carol, so her hand go up first and then I'll come to you. Go ahead please, Carol.
Yeah, I mean, it just makes sense waiting on the Belfast Trust. Paula, I'm just concerned that I think it would be worth getting advice. I know we're getting legal advice today, but there is a non-FOI route where an individual can give an undertaking in pruning. I just want to declare an interest because I brought it in. And it seems that the trusts are just making this more cumbersome than it needs to be. It's almost like they're using GDPR. And this will be a different complexion once a public inquiry comes on board. And I just think in preparation for it, it would be worth getting the legal advice on it and to get a readout from pruning.
Okay, thank you. Carol, go ahead, Timothy, please.
Thanks very much, Chair. Obvious red flags from the responses that we have, that each of the trusts essentially are saying we need money, we need help. Now, I got to highlight the South Eastern Trust, who have been proactive in digitising their records. And surely as a committee, we should be taking what steps we can that all the trusts follow suit. It's the quickest way and the easiest way to access the information. So understand we're going to wait on the Belfast Trust. Understand that to have a collective viewpoint, but there's obvious red flags here straight away, and we need to see what pressure we can put on all the trusts are going to digitise their records to make it easier to get the information people want. From the responses we have today, this is going to be a big problem as we move forward accessing the information. Digitising is the only way to go, and we need to look at, if the Health Minister hasn't money to invest in this, how then do we take this forward to ensure that there is money available to put into staff time to ensure the records are easily accessible by those needing them?
Well, no, they're really good points, and I suppose when we think that they've just extended the time that the Truth Recovery Independent Panel, we're talking £1 million or so, and I would imagine that the Trust would appreciate a small slice of that to allow them to digitise. Carol, has your hand gone back up?
Yeah, I mean, not all public records are digitised. And I know they might be in a fragile state and that, but certainly there are original copies of, there's thousands and thousands of original copies of papers. And I think, I think Timothy's right. They do need to be digitised because they're fragile and they need to be kept. But I think, given the fact that records have been handed in their original form over, needs to be explored as well. I think it's not good enough. It's an acceptable position in terms of where they're at financially, but this is a public inquiry we're getting into, and that won't cut it.
Okay.
I just want to say, I mean, I think today should serve as a very clear warning to the trusts. This information will be required, and you do have to deliver it. And if you're not going to do it for us now, then you're definitely going to have to do it for the public inquiry.
It's being proactive about it.
Absolutely.
And that's what the South Eastern Trust have been, to get them digitised. I have no problem. Yes, everybody has a right to get their original documents. No issue with that at all. But for ease of searching and turning up information quickly, it's a lot easier to search for it in a digital format than it would be somebody manually trolling through. And I know to make them digitised, somebody will have to do that.
Yeah, it's
But
resourced.
let's get on with it.
Absolutely.
Okay. No, thank you. I think you've taken note of that. Yeah. Okay, thank you. So 5.5, Wave Trauma Centre, the response to the bill. So I'm going to refer members to pages 99 to 119 of the pack for the additional information on its response to the inquiry and redress scheme bill. That was sent by Wave Trauma Centre following their briefing at last week's meeting. Just asking you to note this item. Okay.
If I could just raise one point of that they have raised with us about their concern about the exclusion of private nursing homes. So we can read that into the record that essentially that's an issue Wave have highlighted. And I felt it was right to point that out in committee and have it in the public session that that's something they're concerned about at this stage.
Okay. 5.6, Truth Recovery NI. So I'm going to refer you to pages 3 to 4 of the table pack for the additional information sent by Truth Recovery NI regarding additional institutions to the bill, and seek your agreement to note this. But I think that was really useful as well. I think that was something that the Deputy Chair had been requesting as well. So Adopt NI, case studies, access to records, and again this keeps coming up, the access to record stuff. Refer you to pages 5 to 9 of the table pack for a case study sent by Adopt NI involving complexities of access to records, and again ask you to note that. And I think again we'll probably be covering this issue with our first oral evidence session. Okay, are there any actions to be agreed there, please, if we can just recap
Yes,
on those?
thank you, Chair. Carol had mentioned about the committee seeking legal advice regarding the non-FOI route for accessing records. So if the committee are content, we can commission that.
Okay, are we content with that?
And also, thank you, and also to get update and readout from PRONI on the situation regarding the same thing again, so committee can write to PRONI.
Are we content with that action? Yeah.
That's great, thank you. And then I think the other, it's really more for the record, which obviously has been put in there now. So
okay, thank you. So item 6 then, members, we're going to move on now to our first oral evidence session. I'm just going to seek your agreement that Hansard record this session.
Yep.
Okay, thank you. Okay, members, so we're going to have an oral evidence session from Dublin, representatives from Dublin City University and Queen's University Belfast, and I'm going to refer you to pages 122 to 125 of your pack for the clerk's brief, pages 126 to 134 of the pack for the written submission from DCU and QUB, pages 144 to 694 of the pack for additional research sent by the two universities. So, just give them a wee second to just get settled. Okay, you're both very welcome. So I'm going to welcome to the meeting Professor Anne-Marie Magdalene from the School of Law at Queen's University Belfast and Dr. James Gallen, Associate Professor, School of Law and Government from Dublin City University. So thank you both for coming to committee. Thank you for the submission in advance, and if you'd just like to go ahead and make your opening remarks. Thank you.
Thank you very much, ladies and gentlemen, Chairperson, and thank you for the invitation this afternoon. So my comments this afternoon will reflect the joint written submissions from Professor Magdalene and I to the committee, to the consultation process and our recent book with 90 stakeholder interviews. My remarks will focus on some issues with the design of the bill as a whole and then focus on redress. And Professor Magdalene will address the inquiry, the acknowledgement processes of redress and official apologies. So justice measures such as the bill are most effective in our view when designed and implemented in an integrated manner, which sets clear expectations for and builds trust with survivors. To date, the bill and other legislation are, in our view, uneven in implementing the Truth Recovery Design Panel recommendations. The bill does not meaningfully incorporate the guiding principles, and we think mandatory language should ensure that the independent panel report, if published, is integrated into the inquiry's terms of reference. A human rights approach has been recommended by the TRDP and again by 79% of respondents to the January 2025 consultation report. Now, naturally, an inquiry is not a court of law and does not fully determine legal liabilities, but inquiries can and have framed their terms of reference in human rights standards. The ongoing Afghanistan inquiry in England and Wales must determine whether there are credible information relating to serious human rights violations regarding arbitrary and unlawful killings. And I think a similar credible information approach to human rights violations here should be employed in the present bill in addition to the systemic failures approach and the Memorandum of Understanding with the PSNI. Clause 2 regarding the bill's terms of reference should include also reference to the cross-border dimensions of the institutions in question, consistent with the TRDP report, and immediate political engagement between ministers and civil servants in both jurisdictions will be necessary to ensure meaningful access to cross-border information in a timely manner for the inquiry. So our book with stakeholders across the island of Ireland affirms that limited access to records, has a fundamental impact on whether survivors can meaningfully engage with inquiry and redress processes. The TRDP report recommended that the TEO establish statutory guidance for historical, institutional and adoption records and a dedicated permanent independent repository of such records. Prioritising and sequencing that measure is really, really important. You may be aware that at the Hart inquiry, some survivors received disclosure of personal information on the day they were due to give testimony. That type of experience cannot be repeated. Survivors should be equipped and empowered with early disclosure of their records from all public and private sources before they engage with the inquiry and redress. On redress, many of the TRDP recommendations have been implemented in this bill, which is very welcome, but we share the independent panel's concern regarding the exclusion of unmarried women and their now adult children in workhouses before 1948. This cohort is foreseeably small, elderly, but equally deserving of recognition and justice. A commitment to investigate through the inquiry a particular cohort of non-recent abuse raises a legitimate expectation on the part of survivors of their equal treatment for the purposes of redress. Redress for unmarried women and girls does not result in an arbitrary difference in treatment for the purposes of the Northern Ireland Act in Section 75. And extensive research, in our view, affirms that unmarried women were historically subject to discrimination, exclusion and hardship across a range of institutions and outside of residential care. And we see this in the O'Connell and McCormick report in 2021 that affirms that women and girls were subject to stigma in workhouses. And so we would respectfully disagree with the approach taken in the Equality Impact Assessment, that explicitly gendered institutionalisation is required for redress. Secondly, we also disagree with the exclusion of posthumous awards to families of individuals who died prior to 2011. The state's arbitrary. It has no principal justification for restriction and is related to an unrelated inquiry process. Once there's a division made between survivors regarding redress, our comparative analysis shows it creates new hierarchies among survivors that didn't exist prior to that exclusion. But naturally, both of these changes, expanding the temporal scope and including survivors from workhouses, will require revisiting the intended figures for redress beyond the existing estimates. Revised figures for all posthumous awards and for including the workhouse cohort and their descendants should be published, and the potential contributions of religious organisations based on remedial responsibility should be considered. Finally, our research affirms that limited legal advice for survivors at inquiry or redress processes can impact their experience significantly, and so mandatory provision of legal advice in a ring-fenced budget for this would be welcome. Access to these supports, legal aid, information and also counselling are foreseeably necessary for survivors to effectively engage with the inquiry and redress. And borrowing on the Australian model, a single wraparound service and protocol for survivors would ease their experience and increase their engagement. And I'll hand over to Professor Magdalene.
Thank you. Good afternoon, Chairperson, ladies and gentlemen. Thank you also for the invitation to brief the committee on key aspects of the bill. So there are four broad points I would make as opening remarks which speak to the inquiry mostly and also to the redress scheme. So first of all, the first point relates to prescribed institutions and also related to that the reports. So we welcome the capacity within Clause 3 of the bill to include other institutions by regulation, and obvious examples here for future inclusion should this arise from survivor experiences are births and residences in hospitals and private maternity homes. We would also strongly advocate for a modular approach to the inquiry with the potential for running parallel inquiry investigations, which would allow for interim reports to be produced relevant to survivors in discrete contexts. Basically, as soon as the hearing on that institution had finished, you would produce the report. That could then be subject to a final inquiry report with thematic findings and overall recommendations. Second point relates to the composition and appointment of the panel, related to that the advisory panel and the participation of victims therein. So in the composition of the panel, the bill in Clause 5 suggests the possibility of a single judge-led panel with the potential of a larger inquiry panel. But we would say that given the complexities, the known complexities of addressing non-recent institutional abuses, that a larger interdisciplinary panel is necessary to deal with those complexities. Further, it is also vital that survivors are among those directly appointed to the panel, and this has been done successfully in other jurisdictions like Canada and Australia without any issues of impartiality or bias. Survivors should also be consulted on the composition and appointments of the panel as a key part of building their trust and credibility in the process. On the proposed advisory panel in Clause 10, this is also welcome and builds on experiences elsewhere. For example, the Victims and Survivors Consultative Panel, the VSCP, which was part of the Independent Inquiry into Child Sexual Abuse in England and Wales, or ICSA. And the advisory panel is also an important means of incorporating the lived experience of victims and to some extent can mitigate what are known as the harsh and harmful effects of trauma that tend to dominate experiences of survivors of inquiries. However, we would suggest that the language in Clause 10 be mandatory, i.e. an advisory panel shall be appointed, and that explicit consideration be given to the terms of reference of such an advisory panel. Third broad point relates to evidence and procedure. So the research evidence globally suggests that most survivors experience distress or re-traumatisation after participating in an inquiry, largely stemming from adversarial culture and cross-examination. And there are some examples of international best practice which have adopted a non-adversarial approach, such as the Australian Royal Commission, though we wait on empirical evidence to see how that has been experienced by survivors. But the bill itself does suggest some appetite for the victim centering of survivors, and with that in mind, we make some key suggestions to minimise the distress of survivors at inquiries. So, for example, number 1, early disclosure of documents is key. So if survivors would have access to their records, this should happen well in advance of the actual day of the inquiry hearing. Number 2, there could be agreed restricted questioning on cross-examination at the outset of their hearing. And added to this, trauma-informed intermediaries could also be appointed to conduct cross-examination rather than barristers. Number 3, all legal counsel should be trained in trauma-informed approaches and dealing with vulnerable witnesses. And number 4, survivors should also be granted core participant status, i.e. legal representation, as a protection of their rights and interests. Fourthly and lastly, in relation to apology and acknowledgement as part of redress. So the bill talks about redress, the consultation talks about other non-monetary forms of redress, and a key part of that is apology. So for most survivors, redress is about acknowledgement. It's not about money or compensation. And indeed, in our research, acknowledgement of responsibility was the number 1 thing that survivors wanted from justice processes, acknowledgement. So a personal apology to accompany financial redress has emerged as a key part of reparations, as happened, for example, in the Australian National Redress Scheme. So based on a review of international best practice, a meaningful apology contains the following 5 essential elements. This stems from my previous research and actually also formed the structural basis of the first state apology given by the Executive to survivors after the Hart Inquiry in March 22. So these 5 principles are: 1, acknowledgement of wrongdoing; 2, acceptance of responsibility; 3, the expression of remorse or regret; 4, the assurance of non-repetition; and 5, the offer of repair or corrective action. So in sum, on apology, we would say that consideration should be given to an official written apology to accompany monetary redress, and perhaps should even be included within the terms of reference of inquiries in terms of other forms of redress. Thank you.
Okay, thank you very much. Thank you for your submission again. I was saying just before we opened the meeting to some of my colleagues here that some of the thoughts I had in my head, I saw them written on paper a lot more articulate in your submission, so I really, really appreciate that. I just wanted to pick up on a few issues and I'll open it and then maybe come back as quite a number. And I'm maybe going to pick up on this issue of the advisory panel, and you used the phrase clash between the lived experience, expertise and legal and bureaucratic culture in the inquiry. I have a little bit of concern. I think the advisory panel is right to do that, but I just think that there are people there who will be traumatised, feel like they just keep getting consulted and they keep getting their pound of flesh taken out of them all for years as they've campaigned for this. And I'm just wondering how we can ensure that their lived experience can be accessed and presented or worked through the panel, but at the same time not put too much of a burden on them. Any thoughts on that?
Well, I think first and foremost, we know it has to be said that all victim survivors are not the same. So some are different in terms of their journey. Some are more traumatised than others. So I think it obviously has to be voluntary. I think nearly support for the advisors as well. I think some of the organisations that we have, like the Victim Support Service, and we've talked to, the Way of Trauma, all of that can provide support. But looking at examples of what happened elsewhere, members of advisory panels elsewhere, for example in the Victim Survivors Consultative Panel as part of ICSA, the Independent Inquiry in England and Wales, the members who formed the advisory panel there, the VSCP as it was called, they actually had a range of experiences. So it wasn't, survivors who were maybe further behind in their journey. It was very experienced survivors who had leadership roles, who provided support in terms of victim support organisations, who provided advocacy services. So I think the people who do that would have to be voluntary and highly trained and supported. But we have examples of that. Okay,
thank you. The other issue then is around the line you've used there, the suggestion for an inclusion of a subclause around having due regard to the report of the independent panel. And as you know, that panel had been working for years to take down the testimonies, and then had a big flurry there in the last few months, which is great that people have come forward. And I'm really grappling with this as well as to how we can ensure sort of copper fasten that work, which has been going on for years, into this, and then how that then would sit alongside the oral evidence that the inquiry will have itself, because otherwise a lot of it will just be down on paper format. So I'm just wondering if you could give some thought to how the testimonies the independent panel have gathered and how they can feed that into the inquiry.
I think The panel report, which will contain a range of sort of elements to it, and I think it's important that a public inquiry would be able to have regard to all of that as well as the underlying evidence. And so there will be, I think, a need for consideration of the thematic and structural components that come out of the independent panel, but perhaps more legal detail then about how it will have regard to the testimony given to that panel. So a number of inquiries internationally combine formally sworn evidence with unsworn evidence, and if the independent panel is of a less formal nature, that underlying documentation and that underlying lived experience would be going into that kind of other component of unsworn testimony. Typically then that can just sit there. I think better practice is that there would be an obligation on the statutory body then to say, right, well, that was given in an unsworn context, but that should guide our statutory investigations. And that's why I think we're recommending mandatory language, that one has to have regard to the evidence, albeit gathered in a forum without the procedural safeguards that one would have under the Inquiries Act or equivalent.
Unsworn evidence, that's a good phrase. Last one for me is around the suggestion for the apology. We have heard in some of the sessions to date that some of the birth mothers, well, a lot of the birth mothers are now very elderly, and they're concerned that, for example, by the time the inquiry ends, the individually assessed redress, they may not be around to access that. And I suppose there's the potential that could also happen here in terms of the apology, and I just want you to give some thought as to the right timing for that, to preempt what the inquiry says, but also cognizant of the demography of the...
Yeah. Well, you're absolutely right. Sequencing is a key issue. Yeah. So do you apologise at the outset? Now you know that there are issues to be examined, or do you wait to the end of the inquiry till you know what you're apologising for? So that's absolutely a key issue, and there's no kind of hard and fast 100% answer in that. I mean, I think best practice is you apologise early, so the state could give an apology, for example. That could then be followed up by individualised apologies, perhaps, as I said, to accompany redress. I mean, the practice has usually been you get the redress letter and it confirms you're eligible for redress, but there's no other acknowledgement as such. It's an implicit acknowledgement. So an apology could accompany that, as we say. But I think best practice is the earlier the better, given we're living with an elderly population. But that's not to say you couldn't have a formal, more state apology and individualised apologies afterwards as well.
Okay, no, thank you. Deputy Chair, please.
Thank you. I appreciate very much your contribution and the work that you've done, which is of great assistance to us in working our way through this. Can I just ask you to tease out your the discussion point around the human rights-based approach to all of this, and particularly the reference that you've made to the Afghan inquiry in England and Wales. And I suppose in a sense it comes as a bit of a surprise to me that there is no acknowledgement of credible information that comes out in an inquiry on what you do with that. Yep. So if you'd like to sort of expand that a little for us and perhaps give us some guidance and advice as to what we should do to make sure that that is incorporated into the bill.
Excellent. Yeah, so there's a difference between an inquiry, I think, that the state can take the view discharges its obligations to investigate for the purposes of the Human Rights Act. So this inquiry doesn't refer to human rights at all, but we think it discharges that investigative obligation. I think what we've heard from survivors for the book and what we've heard in advocacy in this context is language matters. And framing issues as abuse is important. It's an important element of acknowledgement, but framing survivors as having human rights takes it a step further. And an inquiry can't do the job of determining whether the state breached an individual's human rights obligations. That's a function that we have assigned to our courts in a common law jurisdiction. But what it can do is raise the possibility of further investigation or the acknowledgement that there is a credible level of human rights assessment. So human rights are assessed through courts, but we also have UN bodies that, again, are non-judicial and make assessments of that. So the inquiry can perform that preliminary function. So we see in commissions of investigation at the international level that, again, don't determine rights and wrongs of human rights violations, but do provide credible information about that. So I think an inquiry at a national level could do that. Could be saying, look, we can assess the systemic failings, the holistic assessment of these institutions and their governance and so on, but you will also receive testimony and assess documentation that, when looked at through a human rights standard, Is there credible information here regarding torture, regarding involuntary confinement, regarding coercive adoption, regarding invasion of privacy, and so on? Framing that as human rights violations, I think, adds a lot of value to survivors and opens up the possibility through memoranda of understanding with the PSNI or other bodies that where that reaches a criminal standard, the information can be exchanged for criminal investigation.
That's extremely helpful, and I think it's an area that we want to further develop and perhaps even consider by way of amendment to the legislation to incorporate that. A second area that is of concern to me as well is while the proposed legislation does include the possibility of adding additional institutions, does that turn them into sort of second-tier institutions? The current legislation, or the proposed legislation, has a list, I think it's 11, and they're the front line, if you like. Anybody added to that might be perceived as not quite the front line, and I would have a concern that some of the abuses that we were talking about under the human rights aspect of all of this I think will have occurred in lots of other places as well. So I would like to take your view that if we can identify additional places, should we seek to include those in the bill as it currently stands?
My view would be yes, because based on comparative experience, where institutions aren't initially added, it creates an additional burden on survivors to advocate again, even if there is a statutory power to add things. And that's often happened to be done through lobbying politicians and parliamentarians. And given the elderly cohort we're speaking about, that seems unfair. Where we have information that people will foreseeably lobby about additional institutions, it seems the responsible thing to do to add people in that context. The other dimension of it is, and we looked at the child abuse inquiry in the early 2000s in the Republic, an inquiry often won't investigate everybody, or every institutional context, but where a sufficient number of people come forward regarding an additional institution, that should enable that inquiry to investigate it. So if you've got double figures of survivors coming forward to say this maternity home or this private facility, was atrocious for X, Y, and Z reasons, it would seem very harsh to require them to be lobbying at a national political level to get that looked at.
Just finally, Chair, then the whole aspect of cross-border cooperation and all of this, and I think a concern that's already been flagged to us, that children were, and I'm going to use this word, trafficked across the border in respect of some institutions. How do we tackle that in this piece of legislation?
I think the primary challenge is that there needs to be buy-in from both civil services, and then there will need to be both sub-statutory and possibly statutory agreement on data sharing. We're all GDPR compliant, reportedly, so we'll need to figure out a way to navigate that across two jurisdictions. There is a degree of technical work that needs to be done to achieve that. What I would emphasise is the energy that's required to achieve that has to be led at a high political level, because it's going to take work, it's going to take money, and it's going to need to be done in good time, so that an inquiry can turn and say, well, we have now access to cross-border information from the Republic in good order. The Republic has digitised a lot of information after the Mother and Baby Homes Commission of Investigation there, so the information should be available in a timely manner, but it would again be really upsetting to the survivors and poor use of taxpayer money to establish an inquiry and then go looking to say, let's figure out how to do the cross-border work, particularly if you're trying to stay on time in terms of a 3 or 5 year kind of schedule for the inquiry.
Thank you.
Okay, thank you. Carol, please.
Thank you both for your appearance today, and indeed for your briefing. You've covered some of the areas and the concerns that I have. I just want to ask your opinion on the potential use of public interest immunity certificates as part of this inquiry. I mean, my concern has been that some of the religious and statutory bodies who were involved in this scandal will be given the ability to appear and behind a screen. And while I accept that it's there for a reason, and certainly would be for anyone, even at this late stage, who is almost a whistleblower. I just have a real issue with potentially the perpetrators of these allegations are given that luxury.
Yeah, thank you, Carol. I agree with you. I think it's a real problem. I think in principle it shouldn't happen, but I think in practical terms it might be the only way to get institutions to engage. But I know, for example, the experience of the Ryan Commission and others, anonymity of perpetrators in its various guises, whether redaction or whatever that happened to be, was a major issue for survivors. So to use public interest immunity or the use of screens, something that's traditionally used for victim survivors or vulnerable witnesses, is a real problem. But I think the tension is trying to get the balance between due process, but also it might be necessary, a necessary evil, if you like, to get the institutions to engage. Because I know from our research and interviewing a lot of institutional representatives, current institutional leaders who are coming to inquiries have a real problem with being asked to stand up and account for what their predecessors did, real resentment in some cases 50 years ago. So I absolutely agree with you, but I think we might need it.
Okay, and then I do agree with you in terms of the mandatory language. I mean, currently there's potentially more institutions going to be added to the list, particularly in the use of private nursing homes. And there's still one or two that I've heard reports of that aren't there yet. But I'm really keen to hear about the modular report, because you'll be aware, and I just want to declare an interest because I had to go in front of the COVID inquiry as a former minister. But it has a particular ability to produce reports and to give people, particularly elderly people, who are waiting on almost updates of what the findings are up until a certain point. Would you see that? I mean, and I also agree, we all agree about the passing state, but is that the only way is that the best way of getting a report on and the information out to the victims and survivors and their families?
And that's one of the key recommendations of our research and the book, that you should have a modular approach for that very reason, Carol, because of the elderly population. I mean, the examples of best practice are the Australian Royal Commission and the Independent Inquiry in England and Wales, and they both used interim modular reports where the findings relating to that particular institution were released after the hearings on those particular institutions had concluded. And I think that's, as I said in the briefing, the opening, it's then subject to an overarching final report. So you're not taken away from your final inquiry report, but the idea is that the findings are released earlier for the elderly survivor population, but you're then also gathering the learning from particular institutions and the systemic learning for your final report. So it's something we very much would advocate for.
Yeah, and my last question, Chair, is in terms of so I suppose that would feed into the thematic parts. If it was modular, you could do it along themes, perhaps. But it's a mandatory language, and so the way the system works here, we've asked, will we see the regulations before the end of the passage of legislation? And I don't think we will. I think we should, but I don't think we will. So that for me is important, to have that mandatory language in. So if we make this as strong as possible, we need, in your view, would having more than one person, more than just a chair, ensure that they can stick to the legislation that not only initiated the inquiry, but also try to give almost a bit of a steer on what needs to happen. Do you foresee any problems there with that?
No, I mean, I think most inquiries are led by judges. I mean, there are pluses and minuses to that. Many survivors want that because they see it lends us an air of authority to it. But I think in addition to the legal framework, I mean, we're lawyers, so we're criticising ourselves, but I think there needs to be more than that because of the complexities, I've said, of the issues surrounding abuses, that you need to have a multidisciplinary panel like the independent panel where you're drawing from expertise, not just from law, but trauma, health, all of that.
If I could add to that, we've seen some inquiries publish early on their interpretation of their terms of reference, which gives both the participants and the general public a sense of how they understand the mandate with which they've been given. And if you're adopting a modular approach, one further way to expedite the process might be to run parallel sessions. So you'd have all the investigations of Religious Order A and then all Religious Order B running in tandem. And if there is the written clarification of the terms of reference and combined with the special measures that Anne-Marie has mentioned, such as pre-hearing hearings on questioning and so on, the chair is playing a much more supervisory role of processes that a larger team can conduct. So it's possible that you might get interim reports in double time with that approach. So the more that can be done to shape the conduct of the inquiry at the statutory stage to enable these efficiencies, the better, because I think it'll set expectations for all participants that there is a desire for the inquiry to be expeditious, but also to be fair to all participants.
And I suppose that's why at the very top of your evidence here, you've made that clear in terms of making sure you get it right, because it's really important, especially for the victims here, that they know exactly what's expected. It's not going to be adversarial. The barristers, can actually work out who's asking what questions to whom, and people feel that there's an inclusion. I want to thank you. That's been really, really helpful. Thank you both.
Okay, Carol, thank you. Sinead, please.
Thank you very much. You've practically answered all the questions that I was going to ask anyway, and we've kind of don't want to go over the old road. I was going to ask about that modular report as well, and the cross-border aspect. But just on the cross-border aspect, do you feel that the buy-in from both civil service and a cross-border basis will actually slow down the process, or will it make it more focused and getting to better outcomes?
I think slowing it down is obviously a foreseeable risk, which is why I think early pre-statutory planning is essential. As I said, there's, to my mind, kind of three dimensions to it. One is who's leading the process, whose responsibility is it to ensure the cross-border dimensions are addressed. Something we found with our research was there's a variety of mechanisms in both jurisdictions. None have been tasked with that dimension yet, so it needs to be given that explicit responsibility at an inquiry level, but also at a political level. Second is the technical side of things, from data sharing and data protection, ensuring the personal information of relevant parties are protected. Both jurisdictions are obviously doing that, but this is a new context. Obviously, if it's going to an inquiry, the inquiry has those powers of compulsion that are going to give comfort to all parties involved. But so it is legally, I think there's not an impediment, but it's just going to take time. And the third is just the cost. That's an additional cost that needs to be budgeted for. How will that be distributed across the jurisdictions? I do think there's recognition that this is a missing piece of the jigsaw. I think with speaking to high-level stakeholders in the Republic, there's a recognition that this is an all-island issue, and there is a desire to make sure that as many cohorts of survivors are meaningfully engaged in justice processes as possible. So I don't think there will be a lack of political will, but I imagine there's some major details to be ironed out.
Yeah, and I think, you mentioned in your first response about it needs to be politically led as well. And I think that's really, really important because we have seen in the past where inquiries that don't have that buy-in actually lead to more trauma and more hurt. And I think it's really important that we get that. Well, we get the terms right at the very beginning of this process and around that. And just on the posthumous date, you rightly say that there's no principled justification for restricted there's restriction based on that date. What do you think it would say to the survivors if the department continued to proceed with that date?
I think survivors across the island can be very jaded with engaging with government bodies and have had to spend a huge amount of time and energy getting to the point where this is on the table at all. So for that to be carved out in a manner that's not there before, I think really destroys a lot of goodwill and trust that people have had tried to build up over many years or decades. I think the idea of a cut-off date, I saw in some of the explanatory memorandum, is kind of predicated on the idea that their expectations changed with the announcement of the Hart inquiry, and I don't think that's meaningful. I think the practice on the island is that every individual cohort has had to advocate for their own interests, their own efforts, and so on. And I think it creates an artificially receptive version of the past. That if you were alive on the 28th of September, you suddenly reorganised your behaviour based on what came out of the executive. I don't think that's true. I think people lived with long-term processes of shame, of stigma, of a limited ability to engage with the legal system, or to see, particularly in this instance, to see what happened as a wrong. Because if it was part of the state's welfare provision, it is a qualitatively worse position than someone who was subject to a non-recent instance of child abuse, which was child sexual abuse, which was a criminal offence at the time. We're asking people to challenge not merely what happened to them, but the idea that it was legal or that it was part of the welfare provision. So to say that something fundamentally changed in 2011, I just think is completely misguided. And to communicate that message to people would cause fresh distress and hurt in 2025.
Yeah, if I could add very briefly, Chair, just to say that the date we advocated for in our response to the public consultation was the 25th of November 2021. If I'm correct, 15th of November 2021, which was the date in which the Executive accepted the recommendations of the Truth Recovery Design Panel. So that seems a more reasonable date than, as James said, the 2011 date, which is really tied to the Hart inquiry.
Okay, I'm going to move on, if that's okay. I've got 4 more to come in. Timothy, please.
Yes, thanks, Chair. Thanks very much for coming along this afternoon. Picking up on clause 3 regarding prescribed organisations. So I read into the record, at the start of the meeting, there was a response a paper come in their table pack from WAVE, and WAVE believe that the exclusion of private nursing homes is of major concern. And a note you have regarding clause 3, you welcome the bill's capacity essentially to include other institutions, and you've mentioned births and residences and hospitals and the private maternity homes. This is a common theme essentially that's coming through, that the list we have is short, it doesn't include everybody, and we have put it to a number of groups here. Will come forward if you think that the institution should be included. You've done an extensive piece of work in this. How many institutions, do we need to be looking at here? So we have 11, 12 on the list. Where does this stop? Where do we get to where we believe that we have enough institutions? We have the right institutions. It's not the number. It's about the right institutions that this applies to.
We didn't actually probe the numbers in that because our research was qualitative rather than quantitative. It involved asking stakeholders their experiences of justice processes, what they wanted, how we could do things differently. But my sense of looking at it is, and I think you have a similar view, we talked about this, the numbers are likely to be small, but I wouldn't have those numbers to hand. But it's a very elderly population if you talk about some of these other institutions, so I think the numbers are likely to be small.
I think the other element is that for private institutions, one would expect a different degree of record keeping perhaps than in state operated institutions, I think you'd see that comparatively. So where you start looking at smaller institutional contexts, the records won't be extant for the full period of time of examination, with the result that a lot of inquiry reports might have anecdotal or small references to private contexts, whereas the predominant focus is on the state institutions. So I think opening up the categories is really important because the evidence then will enable the inquiry to proceed. If it is, as I said earlier, a case where dozens or double figures of survivors are coming forward about a particular institution or category of institution, that seems to warrant inclusion. But our view, I think it would be reasonable to expect that they would be in the minority rather than the majority, the larger institutions, particularly around the workhouses and the maternity institutions. One would anticipate being the lion's share of both the testimony that's given and the records that would be examined.
You've said that the number is small. Have you a list of homes that you think should be included? Is that something you can share with us? I'm not asking you to do it in public session, but is that something you can feed in to our deliberations?
It's not something we would have to hand.
No.
There are other stakeholders, I think, who would have access to some incomplete lists of the private institutions, and I'm sure you've met with victim survivors and so on. But no, not to hand.
No.
So there are other groups you might have spoken to directly about that.
Moving on to the modular approach and regarding the parallel inquiry investigations, and I noticed that you have mentioned Good Shepherd. Adoption and I provided a paper that's in our table packs, a case study, and it was regarding information recovery of a birth mother, where they have struggled to get any of the information, but the information they have been able to get, the records confirmed that the birth mother is believed to have spent 57 years in Good Shepherd's care post client's birth. Is that a common theme that you believe, when you have mentioned the Good Shepherd here, is that a common theme within that institution?
There are instances of that in the Republic.
Yeah.
There are instances of women in Magdalene laundry contexts who remain in the care of organisations that originated as an organisation of religious order of female nuns. It is exceptional, but it is not unheard of, either on the island or comparatively with some of these institutions.
And in all them cases, does the evidence point to that person has been kept against their will?
We would have to look into that to give you a definitive answer. But my experience, my read of it is that it's part of the institutionalised process. So while the individual circumstances that surrounded their committal have long since passed, they have become acclimatised, couldn't probably live in the outside world as an 80-year-old if you're there from a 14 or 15-year-old. Working for the nuns has become their life.
And there are instances where there's questions of mental capacity and wardship of court or other forms of legal support to an individual passing to the order. And that's proved quite difficult in enabling such individuals to access redress. So where they aren't legally able to instruct counsel to engage in a redress process and so on, that's complicated their access, which seems doubly punitive in that context. And I think it was only after we ratified and incorporated the Convention on the Rights of Persons with Disabilities in the Republic that position changed. So it is a very small cohort, but a very, very vulnerable and precarious cohort, and one that I think if we are aware of, and so due regard should be had to ensuring that they can have meaningful engagement with both processes, with the inquiry and certainly with redress as well.
Yep.
Timothy, I'm going to move on because I have 3 more people to come in. Pam, go ahead, please.
Thank you, and thank you for your time today, committee. Much appreciated. I suppose just on the back of the question you just answered in terms of survivor supports and legal advice, that is really, really important, especially given this scenario we've just looked at. But what wraparound services should be guaranteed for survivors throughout the inquiry and redress process, and how can access to trauma-informed legal advice be ensured as well? And what role should intermediaries play in supporting that survivor testimony?
So if you look at the Australian Royal Commission into Institutional Response to Child Abuse, they issued a practice direction early on in the lifestyle of that inquiry, and it provided a sort of map of participants or survivors' possible engagement with the inquiry. So you call up. It could be the case that you need access to records. It could be a case that you want counselling. It could be a case you need access to legal advice as to whether and how to proceed. It could be that it looked at both non-recent and recent abuse. It could be that there's active criminal concerns regarding child abuse. But that there was a single number that then directed you to the range of state services. Because what survivors attest on this island is been passed from Harry to Jack. When the Commission of Investigation was operating regarding mother and baby homes, people affected by the issues in Tuam were told, we can't do anything about this, go to the guards will pass them to the Department of Justice, who pass them back to the Commission, and so on. So we want to avoid any ambiguity about what the appropriate support service is. But I think access to legal aid, access to information, and access to counselling are all essential. It might be the case, someone's testimony would be qualitatively different have they access to their own records before receiving that testimony. Someone's ability or interest in receiving redress will be qualitatively different if they know as much as is provided about them in terms of, or their family member, in terms of access to records. In terms of the trauma-informed piece, again, I think a practice protocol is essential, that if you are going to commission as the inquiry a particular legal firm or set of firms to provide legal supports, that there will be a protocol and training provided to ensure that that's done in an appropriate manner. And again, we've empirical evidence, kind of lazy or limited legal advice in terms of accessing redress left people short. You know, just phoning it in from the lawyer left participants short in terms of what they were eligible for under the HEART scheme. So it does make a meaningful difference. And again, it's foreseeably avoided.
And just sorry if I can add, Chair, one of the practical things that survivors have said to us as part of the research, so it's wraparound services means all the supports we've both outlined, not only around the inquiry or redress, but broader than that. So, for example, several survivors told us, you know, if I give my evidence to the inquiry, what support is there available for me at 3 o'clock in the morning when I wake up in a cold sweat and a nightmare? Who do I ring at that time of night? So while there's been great work being done already since 2022 with the Victims and Survivors Service, that's going to have to be scaled up as we go into the redress and inquiry. There's going to be more people, and I think we need to think about those more practical supports rather than just around the inquiry and redress processes, because it's broader than that.
Okay, thank you. That's useful. And in terms of the power to compel information, which is very relevant on the back of that again, is the current provision strong enough to ensure access to the institutional records? And what safeguards could be put in place then to ensure that survivors and their families can access both public and private sources for their records?
Well, I think the 2022 Act showed a great willingness and kind of foresight from the Assembly in ensuring the private records were maintained for this process, for which it has to be commended. But it's only the start of the process, as I mentioned in the oral remarks. Like, a commitment to a one-stop shop for records has been made, and I think that needs to be kind of expedited alongside this. What we heard about the power to compel records from religious stakeholders was actually it provided a legal comfort, because they often were in a position where they said, well, we now have data protection obligations to the people in our records as we see fit, and we're getting restrictive advice in terms of what we can share with people and so on. But being subject to a power of compulsion actually enabled them to go, look, that's that. It's a statutory power, we have to comply, and so we will give over what records we see fit. The frustration, I think, comes when the inquiry receives records that survivors have been looking for years, and that the inquiry team has received them in a manner that's gets ahead of the queue from survivors. So again, the sequencing matters greatly. If that statutory repository of institutional records is created, if there's guidance to statutory and non-statutory agencies in terms of providing access to records for survivors ahead of the inquiry, that's going to get a lot of buy-in, because you're going to get then more survivors coming to the inquiry armed with what has been said about them or their family member in a manner that hasn't happened in the past. We have instances in the Republic where people said, can I have that file you're reading from? And we're refused. That shouldn't be happening, right? So there is a way, like, these are all foreseeable problems. If we have the fullness of time to sequence how we address them, we can mitigate a lot of that. And, we haven't come across an inquiry, subject to what they find in Australia, where people go away going, geez, that was brilliant. That gave us everything we wanted, right? Oftentimes we'll have something that gets over the line in terms of the final outcome, but distresses people along the way, and that's just has to be avoided.
Okay, Pam, I'm going to move on. 2 more to come in. Thank you. Anya, please.
Yeah, thank you, Chair. And I think just going back to your remarks around entitlement to payment and the exclusion of unmarried women and their children pre-1948, could we write to 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 see if there was anything actually flagged within their equality screening that was carried out there? And just to carry on from Pam's point around the compellability element of religious orders obviously having to contribute financially, but is there any comparative measures in other jurisdictions, Canada, Australia, for example?
Marie, do you want to maybe start this time?
Well, this is stuff in redress. Redress is your bag,
Right,
so
okay.
I can come in and
I'm just conscious.
Yeah, thank you.
Yeah, thank you very much.
Thank you.
So the Australians changed civil procedure prior to establishing their national redress scheme, which they wanted to have contributions from private actors. So they made it easier to sue religious organisations, which had previously been very difficult to do because of the charitable and weird status of religious organisations. And that created an incentive for the organisations to enter into the redress scheme where they would receive immunity from civil action. We did the same in the Republic in the early 2000s. We changed the statute of limitations regime regarding sexual abuse only at a time where the religious orders received a large number of litigation, and they came into the state-run redress scheme. There's no example where private organisations just say, yeah, we're a mark. The biggest payouts in Canada, up to billions, are a result of class action. It's a result of litigation and then the litigation being settled. So whether it's actual litigation or it's creating conditions for a credible threat of litigation, that has to be an option on the menu.
Well, I think that's maybe something that we maybe need to drill down into a wee bit more to see what we may have at our disposal. But that's it for me. Thank you.
Okay, Philip, please.
Thank you, Chair, and can I apologise for being late to your evidence session? Just my previous committee overran. Maybe just to build on Anya's point there in relation to compellability of or creating the circumstances that actively encourage religious orders and institutions. Would it be your expert testimony that this bill or other legal avenues should be explored to how we make the circumstances as right as possible to encourage or force those institutions to come forward?
And I think ideally they do it voluntarily.
Yeah. But your research example is that they never do.
Well, not they never do. Some of them are very open and willing. We did find generally very good levels of engagement from the religious orders, but some of them, to go back to what I said earlier, are quite resentful at having to come to an inquiry years later to account for what their predecessors did.
Yes.
So I think, regrettably, I think the bill is strong on that, and I think it does need to be there as a power to enforce them to either give evidence in Clause 16 or 35 in terms of providing documents.
And then if we go on to the redress itself in terms of financial, so Clause 1632 for the evidence, and do you have any advice to us in terms of the circumstances that were created in Australia and parts of which you've referenced there in the Republic of Ireland we should look at pursuing on that front too?
Yeah, I would think that especially with the possibility of a second redress scheme in this context, that should be explored.
Yes.
Anne-Marie's comments by opening, I think, talk about the capacity for redress to form part of acknowledgement. And what our research has tried to do is to broaden out the sense of what that means. Because obviously the resistance from private organisations comes from the sense that we were doing part of the state's job, or we were doing what was right at the time. And what we are trying to encourage participants to consider is that in addition to that question, they may also bear, and we think they do, like a remedial responsibility. You might not have thought you were doing the wrong thing at the time, but there are people here who are hurt, who have gone through a lifetime of difficult trauma or unanswered questions. And unfortunately for you as the leader of a congregation, it's on your head to figure out what to do. And it's perhaps in that context that we see perhaps greater interest among those organisations in making voluntary contributions, because it frames their responsibility differently. It's not you were the only bad guy or you breached the law necessarily, but rather you recognise the suffering and you recognise the potential for addressing that through your institutional responsibility. So voluntary schemes from some of the orders in the Republic in recent years are in more of that model.
And that's a key thing I would emphasise as well, that our understanding of responsibility and accountability in the book is much broader than legal responsibility or legal liability, which is what the religious orders fear. There's relational aspects of it, really showing up as a human being rather than an institutional leader, and also ideological responsibility of the commitment which survivors also want for non-recurrence and doing things differently.
And then just my final question, in terms of the your response to the consultation about the posthumous date, yours was November 2021.
Yes.
Do you have any idea in terms of how many individuals then that would bring into the scope of the process?
I don't have those numbers to hand.
You couldn't mind if you get a chance just to share it with the committee?
Yeah, I can have. I don't know if I'll be able to, but I'll certainly try.
No problem. Thank you, Chair.
Come back in. Go ahead. Timothy,
Possible. We've heard a lot of talk about access to records, and it was a response from the Trust today has triggered this thought in my head. So the South Eastern Trust digitised the records because they say there's a vast amount of them and they're in poor condition. So do we have any idea what state some of the records are in from some of these organisations? If there's a health trust, and I'm being upfront here and saying that credit to the trust for digitising the records and being proactive in this, but they've highlighted a potential flaw here that if a trust has kept their records and they've got into poor condition, obviously because they're years old, when we go, or when people go looking for the records from religious institutions, I have a fear that they're not going to be what they need to be to get them over the line. You don't have any idea of what condition.
And there's various experiences there. Some survivors will tell you they went to the organisation, they were told there were no records, we don't know where your son has gone, only to find out actually the son's living 20 miles down the road. There's also experiences we know James has talked about heavily redacted records. There are other instances where records were destroyed by fire, or institutions have moved, say convents have moved, or like priories have moved, and the records weren't complete because they were taken with them. So you're right, there is a problem with religious institutions. There are multiple sort of anecdotal evidence in terms of the varying state of evidence of records in different institutions.
Is there anything we can do through this bill to try and quicken the process on that people can get their records and see if there's records there? Or is it a case of having to wait till they approach the institution or approach the trust?
Your thought?
Well, I mean,
Cooperation?
the big picture, I think, in terms of records is many are obviously still held by private institutions, and the view in the Republic in terms of developing an essential repository is these are part of our national history. They should all be public records. So under what conditions would the private organisations contribute copies or contribute the originals to National Archives or equivalent? Because again, it seems suboptimal that you would be asking a survivor to piece together the life of a family member through accessing multiple public and private sources or spaces. So again, best practices in Australia with the Find and Connect service that provides that as an advocacy function to survivors, that you would contact the service who would contact all the different kind of bits to it. So there are models in terms of expediting the process, but part of it is cost. How much of the archival work is the state prepared to do? How much archival work have the organisations done?
Okay.
And so on.
I'm conscious that next week we've got the Truth Recovery Independent Panel are coming, and they've been doing a lot of work in this space, so we can maybe move it on very quickly. Deputy Chairman.
Two very quick things. Just a comment on fires. I've heard an academic say recently that he'd never seen as many fires in religious institutions. But other than that, has your research thrown up any what might be described as the concerns about informal arrangements inside families or with neighbours with regards to confinements and adoptions? Informal, not regulated in any shape or form.
You mean that where a family committed their unmarried daughter to an institution? Is that what you mean?
Where an unmarried daughter was committed to a family friend, a neighbour, or somebody who could afford to take them in and then use that child by way of perhaps in service in a household or something like that.
I've heard of that in other contexts, but it's not something that's come out through our research. Sure, it hasn't.
That might be way beyond the scope of the bill. Okay. I'm going to close it there. We've 2 more sessions this afternoon. So, but thank you so much again. Your report was excellent. So thanks. Okay, members, just take your ease for a second while we change. But I think maybe we could do a recap of if there's any points, any potential actions. Thank you.
Thank you, Chair. There were a couple of things that came out that I think we can move up. We can move forward on. The first one, only the point that you made about exclusion of unmarried women pre-1948 and whether the department has any information on the quality impact that they may have looked at on that. We can obviously ask the department on that. Also, I've noted down if the posthumous date changed, how that would then reflect in the numbers of people that may be eligible for either redress or acknowledgement. And again, we can ask the department whether or not they have numbers on that. And the only other one that I had, which which didn't come out of wasn't an action as such, was just one of the witnesses mentioned the Australian map of engagement, which is something I hadn't heard of before, to be honest, but that appeared to be something that might be worth trying to just get to committee so we can have a look at that, because it seems to give a pathway as to how people would engage with an inquiry.
Okay, go ahead please, Carol, thanks.
Sure, it's just in terms of the terms of reference, and even, if you were to take a modular approach, what would that look like in terms of fitting it in to the legislation? I'm assuming it would be like from clause 1 about establishing an inquiry, so
I think
even
that
if
might
it's just
I think that might be one for next week whenever we hear from the Truth Recovery Independent Panel, because if they've been taking all the testimonies, I'm sure they would have identified how that could be broken down, but we could raise that with the department.
it's actually bigger than just testimony. It just lays out exactly the expectations of what the inquiry will do. Most inquiries will just do an opening statement, but I think it maybe needs to be a bit stronger, so maybe looking at the current COVID inquiry, I don't know.
No, I totally take your point. I'm just thinking about how it could be modularised. Okay, thank you, Carol. Go ahead, please, Timothy.
Yeah, regarding the list of institutions, they said they didn't have the numbers to hand, but obviously if they have numbers, they have a list of names. And I think if we could press them to try and share that with us, that would be helpful. They've done an extensive piece of work on this. And it would be interesting to see what names that they have that should be included.
I think that possibly, Clark, if you, with your team, if you could read across all the submissions so far to see if there is, and we can start having a bit of a composite list then around what other, because I think there's a few names so far have been...
Yeah, Chair, and that's something that we would be doing anyway, just in terms of us. We doubled our number of responses over the last 3 days, so it'll take just a little bit of time for us to get through them all, but certainly we'll pull that out, that information for sure. Okay,
everybody content with those actions that we've... Yeah. Okay, thank you. Okay, members, we're going to go into closed session for the next session, so... Okay, thank you. Okay, welcome back, members. We've just finished our session, closed session, oral briefing on some legal advice we had received on public immunity protections and also on the compellability for institutions to contribute to the redress scheme. So we agreed a couple of actions, and I think we should read them into record now and agree formally. Please.
No problem, Chair. Yes, there were a couple of different actions that the committee agreed. One was on a more general level, just to write to the department to get an update on the cross-jurisdictional discussions there have been in relation to all aspects on the bill with the government in the Republic of Ireland. Another action that came to light during the session was that the committee would now like some further legal advice on special measures that could be included in the bill in terms of witness protection and anonymity on those areas. So that's something we'll commission for the committee. And then also a fairly general update on contributions and HIA and where that sits since the last time the committee heard from them. And then also a wider research piece on how the model in Scotland works in terms of contributions for redress, and just also to give members some background as to how the other inquiries and the other models in Scotland and the Republic of Ireland have been working and how they work now.
Yeah. Okay, thank you. Have we agreed with those actions? Yes. Okay, thank you. Okay, members, we're going to move on to our third and final oral evidence session for this afternoon, and this is a report on the PSNI's investigation into mother and baby institutions, Magdalene, Laundries and Workhouses between the years of 1922 to 1990. So members, just as the contributors enter the room, I'm going to refer you to pages 717 to 720 of your pack for the clerk's brief, pages 721 to 732 of the pack for the PSNI's September 2025 report, pages 733 to 741 of your pack for the PSNI's June 2025 summary report. Okay, so I'm going to welcome to the meeting Zoe McKee, who is the Detective Chief Superintendent, Head of the Public Protection Branch at the PSNI, and Jordan Piper, Detective Superintendent at the PSNI. So thank you so much for your papers. We really appreciate you sending them well in advance. But would you like to go ahead and make some opening remarks? Thank you.
Yes, good afternoon. My name is Jordan Piper and I'm Detective Superintendent with the Police Service of Northern Ireland. I'm the Senior Investigating Officer for the Police Service of Northern Ireland's investigation into mother and baby homes, Magdalene Laundries and Workhouses between Northern Ireland between 1922 and 1990. With me is Detective Chief Superintendent Zoe McKee, the Head of Public Protection Branch. I would like to recognise the bravery of the victims and witnesses that came forward and reported their experiences. I also want to acknowledge other victims and witnesses who for many reasons may not have felt able to report their abuse. It is never too late to do so, but I understand that this is a very personal and individual decision. I recognise the huge impact also on those who were born within these institutions and the lasting effects that both victims and survivors continue to experience today. I know there'll be victims, survivors and their families watching the evidence session today, and I hope they are able to take comfort in knowing that the police service undertook this investigation. The Police Service launched the formal investigation in October 2021 following the publication of the independent research report in January 2021 entitled Mother and Baby Homes and Magdalene Laundries in Northern Ireland 1922 to 1990. The investigation team have worked hard to ensure that victims are supported by offering signposting to counselling and health services with an emphasis on sensitive engagement. Where statements and accounts have been given, victims were spoken to where possible and individual letters sent to explain the rationale behind decision making on investigations and to offer a face-to-face meeting with the Senior Investigating Officer. To date, there have been 107 referrals made to the investigation team. The matters reported include rape, incest and child sexual abuse, physical assault and cruelty, issues relating to adoption and cross-border movement, and allegations of mass burials and unmarked graves. Of the 107 referrals, 46 individuals reported an incident in which they were the victim. There were 37 reports from other relatives, most of whom were born within the institutions. 16 reports came from researchers gathering testimonies. 3 reports were made by former employees of an institution, and 1 was made by a current employee within a statutory organisation. 66 mothers were linked to the reports made. Of these, 14 were 16 years old and under when they arrived at the institution. Reporting persons were living in Northern Ireland, the Republic of Ireland, England, Australia, the United States of America and Canada at the time of reporting. The majority of reports received relate to the Marion Vale and Marionville mother and baby homes, both run by the Sisters of the Good Shepherd religious order. In relation to perpetrators, 20 individuals have been named within the reports who belong to various religious institutions. Of these, 2 were working within the Republic of Ireland. 14 of those 20 have been positively identified and 12 of those are deceased. Some of the individuals were born in the 1800s and died prior to the year 2000. 1 individual has been linked as a suspect to 5 reports. They were a member of a religious institution and died before the police investigation began. Another individual who is linked to 3 reports within this investigation also died prior to the police investigation commencing. Currently, 18 investigations remain open, while 89 have been closed due to evidential difficulties. These difficulties include an absence of a named suspect, the suspect being deceased, no criminal offence being identified, or the offence being outside of the statute of limitations for prosecution. There were further challenges as some reports were made by third parties and there was no opportunity of obtaining the victim's account or pursuing further inquiries. Cases remaining open are being assessed individually for evidential opportunities and criminal proceedings. 2 cases are being prepared for the Public Prosecution Service with suspects named. Of these, 1 suspect is being reviewed for extradition proceedings and the other suspect has been interviewed pending file submission. Both of these relate to incidents that occurred prior to the victim's admission to the institution. Where requested and received, institutional records were found to be lacking detail or incomplete. Concerns were raised about the treatment of human remains, including the potential for unmarked graves and burial practices. In particular, the Marion Vale site required examination to establish historical records and potential evidential leads in relation to concerns around mass burials at the site. At this time, no evidence has been found to support this allegation. Not all allegations of harm may amount to crimes under the laws in force at the time, even if they may be considered deeply immoral and unacceptable today. The investigation has had to carefully distinguish between actions that may have been illegal at the time and actions that were moral, immoral or abusive, but not necessarily criminalised. This balance is provided in explaining outcomes in closure letters and trying to manage victim expectations. This also makes clear why some cases may not progress to prosecution, while still recognising the seriousness of the victim's experience and the lasting trauma this has caused in many cases. It has been a privilege to lead this investigation on behalf of Public Protection Branch and the Police Service of Northern Ireland. I'd like to recognise the efforts of the many officers and staff who have contributed to this investigation. Whilst the police service has almost concluded this phase of the investigation, we would encourage anyone with any information to come forward at any time. Lastly, I would like to thank the committee for the opportunity to present this evidence today on behalf of the PSNI. Thank you.
Thank you so much. I suppose we all read the contribution, the submission, with a bit of a heavy heart, and I don't doubt the efforts that you and your colleagues have all gone to try and get to the bottom of these allegations. But I suppose that's the nature of the beast here, the passage of time in many instances. So thank you so much. I suppose the query that's sort of going through my head around a lot of this is around how then with us going forward then with the public inquiry and the potential for new evidence to come forward, and if you could maybe speak to how these will maybe link back in, or how things could run concurrently where new evidence is presented that would meet the threshold for a criminal offence. So does that make sense?
Yeah, we're really conscious that once the public inquiry is underway, there might be further evidence that we haven't had sight of that might identify different offences. It's never going to be too late to report those into us. We will agree some kind of referral mechanism, and we will revisit any investigations that have been closed if new information comes to light. We'll also open new investigations if we believe there's criminality.
Thank you. That's really all from me. Have you anything, Deputy
Yes,
Chair?
just two very brief
Yes, go
questions.
ahead.
First of all, just to get a feel or an understanding of the level of cooperation that you got from institutions when you were conducting your inquiries, both church and other charitable organisations, but also any interaction with health trusts with regards to their legacy responsibilities in terms of your investigations. The second question I have is in relation to most of the focus tends to be here in terms of cross-border between here and the Republic of Ireland, but has there been any interaction with your colleagues in Scotland, England and Wales? Because certainly a recent BBC or recent ITV documentary indicated that children were transferred from England to Northern Ireland to homes.
So in relation to the first question, any institution or any legal representative and any other statutory agency has been helpful to us when we've requested records, where records are available. The bigger challenge has more been the lack of records, or where records have been shared, the incompleteness of them, because there was no standardised requirement to complete records. So that would be more of a challenge rather than information not being shared with us. Second question, yes, where we've needed to, and with any criminal investigation, we would work with other UK police services to share information. But I can't think of a particular case within this investigation where we've particularly had to do that. But it's always an option, and it would be reasonably easy for us to work with other police services.
Just very briefly, do you have either a fear or a concern that when you say, and I think we all acknowledge that record keeping is not identical across all the organisations, nor was there any statutory requirement to keep it in a particular way. But are you satisfied that you got full cooperation, or do you believe that anything was withheld?
No, we are satisfied in relation to the cases where we did seek records that whoever we were seeking the records from did cooperate with us, or we would have escalated to perhaps trying to obtain a court order to access records. But no, I don't have any concerns.
Thank you. Philip, please.
Thank you, Chair. And can I firstly thank you and your team for all the work that you've done on this. It's clearly been a difficult experience, but very, very important. I just want to focus on at the start on the cross-border aspect of this. So, it's well documented that the Republic of Ireland has for many years been a safe haven for criminals when it comes to extradition to the United Kingdom. Did you face any difficulties in terms of cross-border investigations or cooperation?
Not in the way you particularly asking there. So we did have a memorandum of understanding with An Garda Síochána at the beginning of the investigation in relation to information sharing, and we do have processes where we would request and share information through our international policing unit, but nothing specific in this investigation that brought us any challenges.
In terms of the statute of limitations that was in operation in the Republic of Ireland, on page 9 of your evidence it said it makes clear why some of these cases may not progress to prosecution. So were there, in your view, cases that were blocked from going to prosecution as a result of the statute of limitations in operation in the Republic of Ireland?
I can only really speak about the legislation within Northern Ireland, which, because the offences that occurred in the Republic of Ireland would not be within our remit to investigate. In relation to Northern Ireland, so we did have a number of allegations relating to an adoption process and whether that was valid. There was a criminal offence attached to the adoption legislation, but that became statute barred after 6 months. So prosecution could only be started within 6 months of that day. Obviously, we know the situation that many of the victims were in at the time. I'm sure would not have even known that there was a potential offence, let alone be in a position to challenge that. So that has presented a challenge with the bulk of those allegations that relate to adoption, because there just hasn't been anything that's in legislation today.
And does that then, so on the section of legal versus moral accountability, your evidence said that not all allegations of harm may amount to crime. So could you give examples of that?
Yes, so the general sort of mistreatment that was experienced within the homes, or potential allegations of financial abuse. There was potentially allegations of not being allowed to leave the home, but rather than that being, by force, not being permitted to leave by force, it was part of the vulnerability of the victim and their kind of understanding around what they could and couldn't do. So things that we understand now were completely reprehensible, shouldn't have happened. There was nothing to say that those were illegal at the time when they happened.
So like false imprisonment, that wasn't have been covered by?
We did explore allegations to see whether it was false imprisonment. We sought legal advice on every single case, as well as overarching legal advice to see what offences would be there at the time, but there was nothing that fitted the offence of false imprisonment.
Okay. Did you say you have one application for extradition, Karen? And where is that from?
Don't really want to give too much information on a particular case.
Sure. No problem. And you're preparing another application, did you say?
There's two. So one's an extradition application, and just because it's an ongoing case, I don't want to speak about it at the time, but we will fully disclose all information once it's concluded. The second case is a file that's been prepared to the Public Prosecution Service. That doesn't involve extradition.
Okay. Thank you, Chair.
Okay, thank you. Carol, please.
Thank you for your presentation to the committee today. It's really appreciated. So a lot of questions have been asked. One question I'm not really clear on, or one area. Has the Guards ever contacted the PSNI in the North in relation to investigations regarding the inquiry that happened in the South, similar inquiry? And in relation to, I couldn't hear you properly, but did you say that you're content that you've seen all the records from the institutions as part of your investigation?
So in relation to the first question, we haven't been contacted by colleagues in the Guards specifically around any investigations, or not to my knowledge. And then in relation to the second question, that there is nothing that makes me think we weren't given the records that we asked for. We were provided with. There's nothing that has made us think that anything was concealed from us or not provided. But I can't 100% say they gave us everything because I don't know what they have. If that makes sense.
Really, I mean, the records would have been, their registration books and things like that, just to be clear.
Yes, yeah.
And it would have been around who was there, who was brought in, where they had their baby, and if their baby was adopted and where it went to.
Yes, so in the cases where we've requested records, we do have the initial admission sheet with the information around that, and we do have letters in some cases relating to adoption from social workers, and other sort of items that might be relevant. So, but we did not receive comprehensive records, but it's my understanding that comprehensive records were not kept.
Okay, thank you.
Okay, thank you. Timothy, please.
Yeah, just picking up, so Marianville, the site examination. We have heard at committee that there is a number of sites being suspected for mass burials. Is the police aware of any others apart from Marianvale that you've already looked at?
No, we've only been provided with information in relation to Marianvale, but I am aware as well around Milltown Cemetery, if that's the other one referring to. But other than those two,
there has been others. Was there one in Oma?
I can't remember off the top of my head, but maybe we could.
As this inquiry gets going and other sites are identified and potential evidence brought forward, is the police open and going to be engaging with the inquiry that other sites will be examined as they come up?
Yeah, of course. Yeah, we'll investigate all allegations of criminality, whether that's in relation to a burial or an assault or anything else.
107 cases, 54 of them completed, so many still ongoing. The last time you came to committee, that was the figures that were given. From memory, what's the updated position?
I have never presented to the committee.
There was some information that we talked to at one of the familiarisation days in the summer. Was that possibly what you were talking about?
Was the police not at committee?
Maybe there was a written submission. I think it was a summary report. Yes. Yeah, there was a summary report, but it was in your pack as opposed to an oral evidence session.
I talked here about 54 live investigations. It is anticipated that the majority of these will be finalised by the end of July. So I'm fairly sure I've seen that before. We're now in September. Where are we at today?
Right, so just bear with me because
my understanding is that there was the summary report was given, I think, around summer this year.
That's right.
And then obviously we're attending today. The figures that you've been given today are the most up-to-date figures. So I wouldn't anticipate that they would have significantly changed since that summer report to now.
So on page 4 of the report that I've submitted for this session, there are, and what the information I gave in the opening remarks are, there's 18 investigations that remain open. So those 18 cases we're assessing for evidential opportunities.
The 54 investigations that are ongoing that we have here are down to 18 now?
The evidence that I've submitted for this session is there are 18 investigations that remain open.
Regarding your social media campaign, very interested, essentially that's something that's come up in quite a bit of discussion over the last number of months of how we target people that may been affected. So you have used the USA, Canada, Australia, New Zealand, as well as UK, and the geographical locations you've been targeting. Have you any figures of people that have come forward from any of them locations?
I don't have those with me today, but I can provide you a written update afterwards with a breakdown of the 107. But of those 107, they came from Northern Ireland, the Republic of Ireland, England, Australia, USA and Canada. But I can give you a breakdown of those afterwards.
If possible, because it would be good to understand how many of them that have been reached through the social media campaign. The committee has a list of different contexts of how we can get our message out, and if the police have already established people coming forward from other countries, they may well be able to help us to widen that net if possible. Regarding the records, so what has come forward, and I've raised this a number of times today, one of the trusts have digitised their records because the vast amount of them and the poor condition that have been kept in. Of the records that you have seen from the institutions, can you give comment on what sort of condition they're in? Yes, understand there's gaps. One may argue they're not fit for purpose. They wouldn't be kept in a condition, or the information contained wouldn't be what we would expect today. But as of the condition of them, physical condition, are they digitised or are they in paper format?
A combination. The ones that I've seen, handwritten, so difficult to occasionally read someone's handwriting, but not to the point that you can read what's been written, and then some are typed letters. So that there hasn't been a challenge in terms of the investigation in relation to not being able to read the records.
Out of the list of all the different crimes that have been alleged, how widespread is child abuse in that?
How many what, sorry?
How widespread would child abuse be in what you're investigating?
There are not many investigations with child abuse. We can share the analytical report once we've concluded all 107 with you, so you can see the exact breakdown, but there are not a lot of allegations.
Yeah, other European countries have a child abuse commissioner, so I'd be very interested to see the information that you are considering, how widespread it is. Do we need a prevalence survey across Northern Ireland of how widespread essentially it is? And it would feed into that piece whether Northern Ireland needs its own child abuse commissioner or not. Other countries have them, and I'm just trying to get a context from yourself if that's something that we should be looking at. And that's all my queries. So if you could provide that information after the session, that'd be helpful. Especially the social media reach and what sort of response you've had from that.
We did quite an extensive media campaign, so I'd be really happy to share all of that with you because I believe it's been successful.
Even costs involved, the locations you targeted, all that information would be very helpful as we move forward.
For example, even in relation to the work that we did within Northern Ireland, so 1,500 leaflets and 250 posters were distributed between each policing district of Northern Ireland. So, it was extensive.
On the leaflets, how did you target geographical areas out of that?
So, it was equal across Northern Ireland, so the same distribution through each policing district. But we did also look at different community groups. So, and we also looked at agencies that worked with adoption, and we also spoke to other organisations, for example, HNI and Commissioner's Office for Older People in Northern Ireland, given the potential age of some of the victims, and we asked our information to be included in their newsletters.
No, thank you.
Just to clarify, so you supplied us with a summary report in June, and then at that time I think we'd asked could that be shared with the victims and survivors groups, and you said actually we'd like to conclude.
Yes.
So that's why you're here today, because you said concluded all your investigations. So just to tidy that up a wee bit. Anybody else got any other questions? No. So thank you again.
Thank you so
Thanks
much.
for your work on this. It's a really important, sensitive subject. So thank you.
Thank you.
Okay, members. Just going to move on then. Were there any actions out of that, Clark?
More updates that the committee will get from the witnesses, breakdown of geographical area of people coming forward outside of Northern Ireland, breakdown of the media campaign, including costs, geographical spread, and which groups were contacted, and then also numbers in terms of allegations of child abuse as well. So those are things we'll write back to the PSNI asking for those specifically.
Okay, thank you. Anybody got any comments before we move on to correspondence, or no? Okay, thank you, members. I'll move on to say to correspondence, and you'll find these on the summary of committee correspondence in 744 to 751 of the pack, and just would like to draw your attention to a number of items. 9.8 Committee for Finance, Administrative and Financial Provisions Bill, and you'll find this on pages 344 to 346. So the Committee for Finance has written to the committee again regarding the Administrative and Financial Provisions Bill, and in particular clauses 6, 7, 8, 9, 10 and 14 of the bill, which contain policy proposals brought forward by TEO. Just to advise that the committee wrote to the department on the 2nd of July to ask for a written briefing on the 7 clauses highlighted and what, if any, impact they will have on the department. The committee team has chased this with the DALO, who has advised that a comprehensive response is currently in the system and is being considered by ministers, and that they are aware of the response time to the Committee for Finance. So I'm just asking you to note it for now. Okay, so 9.14, I'm going to refer you to pages 1008 to 1011 of your pack and 1157 to 1160 of your pack, and this is in relation to the department response to the committee correspondence on the 10th of July regarding the End of Violence Against Women and Girls Strategy Annual Review process, and the committee's correspondence on the 12th of September. just passed in relation to the strategies commissioned research. Just remind that officials will brief the committee on the End of Violence Against Women and Girls strategic framework and its first year delivery plan at its meeting on the 19th of November. So I'm just asking you to note this correspondence. 9.8 TO response, recent disorder across Northern Ireland. I'm going to refer you to pages 1012 to 1016 of the pack. That just to advise that the Department has responded to the Committee's correspondence of the 13th of June in relation to their approach regarding recent disorder across Northern Ireland. Just a reminder that officials will brief the Committee on race relations at its meeting on the 12th of November, as well as the PSNI on its race action plan. I'm just asking you to note at this stage. Okay. 9.8, the Executive Officer's response in terms of PFG delivery and the delivery unit. And I'll refer you to pages 1161 to 1164 of your pack. And just to advise that the Department has responded to the Committee's correspondence of the 12th of September regarding further information on the delivery of the Programme for Government and the role of the delivery unit. Just to advise that TO have outlined that the delivery unit will collaborate with departments to investigate, intervene, push ambition and pace and provide support and challenge to solve problems and develop a range of actions to effect change. In addition to direct ministerial oversight, the delivery unit will also contribute to the arrangements in place to monitor progress across all 9 PFG priority areas. And just to remind that officials will brief the Committee on the PFG delivery at its meeting on the 22nd of October. And I'm asking you to note this correspondence. So I'm going to ask the clerk to read some other items into the record. Thank you.
Thank you, Chair. Items 9.2 to 9.5 are Hansard reports from recent sessions. So that includes Birth Mothers and Their Children for Justice, Truth Recovery NI, Birth Mothers and Their Children Together, and the Consultative Forum at the Committee's meeting on the 17th of September. Item 9.6 is correspondence from the AERC, the Assembly and Executive Review Committee, regarding review of Assembly Committee engagement on cross-cutting executive strategies. And Chair, if I could ask members if anybody has any views on that particular issue, if you could get those to me by the end of the week, I will then use those to draft a committee response, which can be discussed at the meeting next week on the 8th of October. That's okay. Item 9.7, Committee for Finance, Cybersecurity and Resilience Network and Information Systems Bill, for members to note. Item 9.10 is from Queen's University Belfast, and it's an invitation to AI in the Future of Work event on the 22nd of October. Any member who wishes to attend should use the link within the invitation to register. Item 9.11 from the NI Judicial Appointments Commission, again an invitation to an engagement session with the NIJAC on the 17th of November, and a formal invitation to that will follow shortly. Item 9.12 is the Department's response to correspondence from the Committee of the 12th of September, an update on the investment strategy. Item 9.13, correspondence from the Committee for Communities on the visibility of minority and Indigenous languages. Item 9.16 was a departmental news release of junior ministers welcoming the start of work on the DNA Museum. And item 9.17 is from the Committee of Finance, which is an analysis of the 25-26 outturn and forecast outturn.
Okay, thank you. I just want to raise, and not necessarily in the correspondence today, but it is the outstanding response from the department that when we wrote to them, I think it was April, keep me right please, Assistant Clerk, around the department's analysis on the value for money for its Beijing office. Obviously at the time I had raised queries around the value for money to the public purse, and I had suggested possibly this is something that we could refer to the Public Accounts Committee to look at this. And at the time I think Carol had suggested, can we just write to the Executive Office first to ask them for their assessment on but they have not done so. So can we chase that letter up one more time, and then I do want to revisit this.
Yes, sir.
Any other matters under correspondence people want to raise? No? Okay, thank you. So I'm actually going to stay with you, Assistant Clerk, and ask you to talk us through the draft forward work programme. Thank you.
Thank you, Chair. So it's just to seek agreement for members for a briefing that's not actually until December, but will come around quite quickly. So on the 3rd of December, we're going to hear from the Department to provide an update on the strategy for victims and survivors. So as part of our strategic planning, we also agreed that we'd seek views of stakeholders on the strategy to see how it's working. So it's just to seek out initial invites and get the groups the members would wish to hear from. Previously we've heard from SEF, the Eli Centre, WAVE and Relatives for Justice on the Victims Payment Scheme, so it's just to see if members are happy that those groups are initially invited, and if you have any other suggestions to let us know, and we'll include them.
Yeah. Could I include Bridge of Hope in North Belfast, because they've been in contact regarding changes in the application for victims payments, which is going to actually it's going to prevent a lot of people from applying, and I think the application, the way it's written, would appear to be that the victims and survivors unit have taken direction from TO. That's what's been said out there, and I don't think that's the case at all.
Okay, go ahead.
Yeah, no, I'm happy with that. I was going to make the same suggestion. So, Bridge of Hope, who are based at the Ashton Centre in North Belfast, they are one of the contract holders, so they'd be useful to.
Okay, thank you. Okay, so members, are you content to proceed with the remaining briefings as set out in the work programme?
Can I just ask one question on the forward work plan?
Yeah, go ahead.
Just obviously because I'm new to questions. So I see next week we have the Human Rights Commission. Is that the Chief Commissioner who's coming?
Yes.
Okay. And in terms of the scope, what is she coming to? She's coming to present on.
Bill.
Okay. And then just secondly, in relation to the law firms that are coming to give an oral briefing, just wondering how they were selected.
Well, Chair, if I may, yep. So those law firms have actually already been involved in some of the representative groups, in terms of, so they've been identified previously, and as they've already provided legal advice to those groups, they have a vested interest in the bill.
Okay, so they're coming to give us their view on the bill?
Yes.
Okay. And did we seek wider views? Obviously, we've got the Law Society, which is important. But
yes.
Did we?
The Law Society. Yes.
Yeah. And I see they're listed. But did we seek wider representation? Because I assume that those two law firms aren't the only people that have represented any victims or survivors.
Yeah, we can send you the list of the stakeholder that was agreed back in, I think it was late June, and you'll be able to see everybody that we contacted from that. That's okay.
Thank you.
That's no problem.
Okay, content? Okay, thank you. Any other business members? No. Okay, thank you. Okay, so date, time and place will be next Wednesday the 8th of October at 2 p.m. in this room. The meeting is adjourned.